The Appellate Division First Department is now in session. Good afternoon and welcome to the admission ceremony for our court. Ms. Guerrero, please proceed.
May it please the court, good afternoon. I, Veronica Guerrero, counsel to this court's committee on character and fitness, am honored to present 37 applicants to the court for admission to the bar. Each of these applicants has met all of the requirements necessary for admission to the New York State Bar. Further, I am pleased to report that the committee has examined the records of each and every candidate here today. Accordingly, and on behalf of the committee, I certify that each applicant here this afternoon does possess the requisite character and fitness to merit admission to the bar of the state of New York. Therefore, I do hereby move for their admission.
Thank you so much. Ms. Guerrero, on behalf of this court, please give our thanks to the committee members for their pro bono services in conducting the review process required for the admission of new attorneys. We are eternally grateful to them. And while our court is always known for quick disposition of motions, and normally we don't take longer than 2 weeks, my colleagues have given me permission to grant this motion this afternoon. The motion is granted.
Thank you.
The clerk of the court, Susana Rojas, will now administer the oath of office. Good afternoon, Ms. Rojas.
Good afternoon, Justice Mansonet Daniels. Good afternoon, candidates. I will administer the oath of office in the form of a question. At the end, I will ask you to unmute your microphones and respond by saying, "I do," if you agree. At this point, I ask everyone to please raise your right hand. Do you solemnly swear or affirm to support the Constitution of the United States and the Constitution of the State of New York, and to faithfully discharge the duties of the office of attorney and counselor at law to the best of your ability? Please unmute your microphones and respond by saying, "I do."
I do.
I do.
I do.
I do.
I do.
Congratulations, attorneys. You may lower your right hand and please mute your microphones. Thank you.
I now invite my colleagues to unmute their mics and give our new attorneys a well-deserved round of applause. It is our court's custom that one of our justices gives welcoming remarks, and today that pleasure falls to my brother, Justice Peter Moulton.
Thank you, Justice Manzanet. To all the new lawyers in this virtual room, congratulations. 34 years ago, I was admitted in the first department. I don't remember who the justices were present that day. I don't remember much about the remarks of the justice who addressed us newly minted lawyers. I do remember asking myself, when is that guy going to stop talking? So I will be brief. You're joining a vital profession, one that is a crucial component of government, of the economy, of all aspects of a well-ordered society. It needs good people to run properly, and you are literally our newest recruits. Our legal system, along with similarly independent legal systems in a handful of other countries, is the envy of the world. A majority of nations probably do not have the rule of law as you and I understand it. They do not have fair, fully functioning legal systems. By contrast, in New York City in particular, our state and federal courts are a destination for commercial entities from around the world who, if they must engage in litigation, wish to do so in a forum that is free of political and commercial biases and that renders decisions in a reasonable amount of time. Indeed, corporations around the world often write into their contracts forum selection clauses that designate the commercial division of Manhattan Supreme Court as the court where any litigation arising from the contract will go forward. The importance to business of a fair and impartial court system cannot be overstated. Without it, businesses are reluctant to commit capital and take risks. Our legal system has also been a means for moving our nation forward on civil rights. For those of you, probably the majority, who are fresh out of law school, cases like Brown versus Board of Education, Estelle versus Ruiz, Gideon versus Wainwright, Frontario versus Richardson are fresh in your minds. Perhaps you read biographies of lawyers who changed aspects of our legal system for the better, such as Pauli Murray, Thurgood Marshall, and Ruth Bader Ginsburg. Perhaps you take inspiration from them. However, you should never consider our legal system to be perfect and immutable. Our legal system is a work in progress, and you all have a role in changing it for the better. A moment ago, I spoke about how well we do in commercial litigation and how we attract the world to our courts. However, other aspects of our legal system are sorely in need of attention and resources. Poor and working class people often have no access to a lawyer in civil litigation. In criminal courts, our assigned defense counsel do an often heroic job, but they are overworked and under-resourced. Having no lawyer or having an overwhelmed lawyer is a disability in seeking a fair outcome. Economic status should not determine outcomes in our courts, but too often it does. Obviously, there have been times in our nation's history where lawyers have played a malign role in perverting our legal system. Joseph McCarthy was not a lawyer, but he was assisted by very able lawyers in his red baiting. Lawyers working for large corporations have, on occasion, gotten away with criminality in obscuring the health effects of dangerous products. Prosecutors have, on occasion, acted to enforce white supremacy in our criminal justice system. The imperfection of our legal system is reflected even in the First Department's beautiful courthouse. If we were sitting in our courtroom right now, you might look up into the stained glass dome in its center. You would notice the names of a number of legal luminaries, such as John Marshall. However, that cupola also contains the name of Roger Taney, the Chief Justice of the U.S. Supreme Court who wrote Dred Scott versus Sanford, in which the U.S. Supreme Court held that the privileges and immunities of the U.S. Constitution did not apply to African Americans, whether they were enslaved or free. The presence of Taney's name in our beautiful courthouse is a reminder to me of our imperfect legal system and how all of us as lawyers must work to improve it. How can you do that? First, you should do pro bono work for underserved communities. That's truly a win-win endeavor because it will simultaneously help out someone who needs help in a landlord-tenant dispute or a criminal matter or in a commercial debt case, and it will give you hands-on legal experience and greater responsibilities than you might have in your job. Second, you should join one of the numerous excellent bar associations that exist in New York City. A bar association's very mission is to improve aspects of the profession. In sum, remember that you are a member of a vital profession that can be an immense force for good. Act with integrity, with intelligence, and with heart. Good luck.
Thank you so much, Justice Moulton. This admission ceremony is now concluded. I bid you a farewell and a good afternoon. This honorable court stands adjourned.